Okay, I think we are. I think we're live now. So welcome everybody again to today's webinar event. The webinar event today is entitled OSHA, Discrimination, FMLA, and Our Aging Workforce. And the voiceless or the faceless voices that you're going to hear over the next hour or so presenting this this message is Eric J. Conn and Jordan Schwartz from the law firm Conn Maciel Carey. I'll introduce myself real quick, let Jordan introduce himself, and then we'll jump into the content here. I know many of you, but I do see that there's a lot of names registered for today's event of folks that I haven't met before, so let me tell you who I am real quickly. My name is Eric Conn. I'm one of the founding partners and the chair of the OSHA Workplace Safety Practice Group at Conn Maciel Carey. My practice focuses on all aspects of occupational safety and health law. I work with employers to help manage inspections, investigations, and enforcement actions primarily involving OSHA and the various state OSHA programs out there, but also some of the other agencies that have a regulatory role in managing safety and health in our workforce. Chemical Safety Board, Mine Safety and Health Administration, EPA, and other state and local agencies as well. In addition to the enforcement side of workplace safety and health, I also help my clients develop and implement safety and health programs, provide safety and health related training, and also perform or direct for purposes of protecting under attorney-client privilege safety and health related audits of the workplace to identify compliance gaps, fix them, and not have a tool to hand right over to a regulatory agency showing where those gaps are. I also speak and write regularly on safety and health issues like I'm doing today during this webinar, and I'm so pleased to join you all today. I'm going to turn it over to Jordan to introduce himself.
Thanks, Eric. For those of you that don't know me, my name is Jordan Schwartz. I am a partner at Conn Maciel Carey, and we have been in existence now just coming upon 1 year. So it's nice to have been here for a full year already. And I work with Eric, although he focuses on the OSHA aspect, defending our clients, I focus almost exclusively on the employment aspect. And in that capacity, I help defend employers on all aspects of litigation, whether it's an age discrimination case, whether it's Americans with Disability case, whether it's wage and hour, and it really runs the gamut of anything that your company may receive a claim by an employee, we represent. We also do a lot of counseling, so like this session right here, so we can avoid needless litigation in the future. And, you know, the counseling is all from onboarding and hiring to termination and everything in between. And we also do represent employers in traditional labor matters, you know, and everything to do with collective bargaining and handling a unionized workforce. And I look forward to speaking with you in a little bit about the Age Discrimination and Employment Act and how our aging workforce, how they are affected by the Americans with Disabilities Act and the Family Medical Leave Act. With that, I'll turn it back over to Eric to begin the OSHA portion of the presentation.
All right. Well, so you've been able to tell, I'm sure, from the title of this event, some of the background materials maybe you've read in anticipation of the event, and also the fact that Jordan and I are co-presenting and describing our practices in fairly different ways. Now, I'm an OSHA lawyer. Jordan is an employment lawyer. It's one of the things that I'm really excited about this particular webinar topic is that it really showcases the two specialty areas of our firm. You know, we're not a giant firm with covering all bases in the law. We are an employment boutique firm, and we really do two things at this firm, employment and OSHA law. And today's topic is a perfect overlap of those two areas of law. So here's on the agenda what we're going to be talking about. First is, you know, we're talking about this aging workforce. What are we talking about? What are the metrics that demonstrate that this really is an issue and perhaps even a crisis type of issue in the workplace? what are some of the causes and contributors to the fact that our workforce is aging, is getting much older. And then we'll talk about these two areas of law where Jordan and I specialize. I'm going to talk to you about the OSHA workplace safety and health-related issues that are impacted by an aging workforce. And I've identified a few issues, the most significant being ergonomic-related issues, hearing loss issues, and general safety and health, and how all of that rolls into injury and illness record keeping, and therefore perhaps a significant increase in OSHA enforcement due to rising record keeping data because of a physically vulnerable workforce and some of the issues that arise in that area. And then Jordan is going to cover the major employment law areas that are impacted by an aging workforce: the Age Discrimination Employment Act, Americans with Disabilities Act, and the Family Medical Leave Act. So let's talk about the aging workforce. There's all sorts of fairly remarkable data out there about what's going on now and what we expect to continue for the next 15 years. The number of people aged 55 to 64 will increase to almost 40 million in the year 2014, which is fast already, and to 42 million by 2024. This isn't the workforce. This is our population here in the U.S. 40 million in that range of workers who are reaching traditional retirement age. And what's going to happen, what we're already seeing happen, is that the folks that are hitting those traditional retirement ages are not leaving the workforce. So we're saying that the participation rate in the workplace for employees, for workers who are age 65 and older, is increasing leaps and bounds over the last several years and continuing and projected to continue for the next 15 years or so. We're seeing that the workforce is made up now, approaching 20% of the workforce is made up of employees who traditionally would have retired already at the age of 65. And you can see the growth trend in that number, and that is expected to continue. The aging workforce is a result of fewer teenagers are working now, which means that that changes the average age of the workforce, but it also means that jobs are needed to be filled by older workers. Fewer women are staying home. In 1998, about 60% of women in ages 25 to 54 were not participating in the workforce due to home responsibilities. In 2013, that number was down to 53%. And then fewer men are retiring or retiring at traditional retirement ages. In 1998, almost 87% of men 55 and over said that they were out of the workforce because they were retired. That number is down to 79%, cited that same reason in 2013. And then here's the number. We talk about how just our population is aging. 10,000 people in this country will turn 65 years of age every day until the year 2030. That's an average between now and 2030. There's actually quite a few years in there where the census projects that it would be up to 15,000 people per day turning 65 every day in this country. So you can see where the data is headed. Here's some other interesting information about the aging workforce. It used to be that many of the folks who were still participating in our workforce after the age of 65 were participating in part-time status. Well, that line, this graph here on the left, that line is changing fairly significantly. It crossed in about the year 2001, 2002, and it's just moving totally the different direction, where workers, and senior workers over 65 who remain in the workforce are remaining in the workforce in full-time capacity at significantly higher levels than before, and that same data point for part-time participation is going down. So we see that people not only are working past 65 at a higher rate, they're working past 65 in a full-time capacity at a much higher rate than ever before. You can also see in this graph on the right that shows the percentage increases in senior workers who are staying in the workforce between the 1970s to into this decade, where we've seen 100% increase in workers over age 65 remaining in the workforce. Women over age 65 remaining in the workforce, 150% higher rate than we've seen historically. And then you can see not only is it that, staying in the workforce from 65, instead of 65, it's 66 or 67, we're seeing that employees over the age 75 have increased by over 170% over the last 3 or 4 decades. So you can see where the trend is headed. Our population is changing. Our workforces are changing in fairly dramatic ways. A couple of more data points on that topic. This shows some more recent data from the U.S. Bureau of Labor Statistics that the percentage change between 2006 and 2016, that last graph showed generally what was happening over the last 40 years. Now let's look just back over the last 10 years and what's projected to happen over the next year, that workers over the age 75 are expected to remain in the workforce almost 85% more than they did 10 years ago. Same number, around 84% for workers in that 65 to 74 range. So the increases are stark. Another interesting data point that I thought was particularly interesting, looking at this from an OSHA perspective, from the traditional HR issues, traditional employment law issues, probably doesn't make a whole lot of difference what industry employees are staying in at a later age. But from an OSHA standpoint, that certainly matters. And there's some industries listed here that really surprised me for where we have this, surge of much more senior workers remaining in the workplace. Retail trade, wholesale trade, transportation, and warehousing. 23% of that workforce is made up of workers over retirement age, over traditional retirement age. Construction and maintenance, 24% employees in those industries are senior employees. I mean, these are, labor-intensive, physically strenuous jobs. Transportation, jobs that require, focus, alert, the ability to sort of sit in maybe awkward postures for long periods of time. Also on the list, healthcare and social assistance. At 30% of that workforce is made up of workers past traditional retirement age. Manufacturing, 26%. Mining, quarrying, oil and gas extraction, 27%. These are physically demanding types of work where we have a changing demographic moving from the 25 to 45 range and shifting up that age ladder to more senior workers. So you can imagine the types of OSHA safety and health related issues that may be impacted by this. So why is the workforce aging? I mean, there's some obvious factors. Everybody dialed into this webinar is already thinking about. Our life expectancy is changing, and this is a good thing. People are living longer, not just living to a later age, but living healthier lives much later into their life, which facilitates the ability to continue working later in life. And it also creates a greater need to work later into life, because if you're going to live longer, you will need the means to live that longer life, to continue to afford your housing and your needs and wants as you grow older. You will have to work later into life to be able to accommodate those things. Some other factors that were maybe less obvious to me as I dug in and started to research this issue. One is that there has been a fairly significant trend in a change in the way we save for retirement in this country, moving away from defined benefit retirement plans to much higher percentage of defined contribution retirement plans. So the defined benefit plans would continue to provide you a certain benefit regardless of how long you live past retirement, or at least for a significant number of years defined or set past retirement. And that's no longer how most American workers are saving. So if you're saving by putting in a certain amount each year, but not guaranteed a benefit for many years of retirement, that means you may have to work later into retirement to be able to accommodate the longer life expectancy. Also, an interesting data point that has affected how late workers are staying in the workforce is that the average age that a person first marries has gone up significantly. So this, sort of shifts back the starting of the family and all of the things that you do in life to spend on your kids' college, to set aside for retirement, and then to get your kids out into independence is shifting later into life because people are getting married later in life and people are having kids later in life. So it's another reason why people are staying in the workforce later. We've also seen a decline in the amount or the quality of retirement health benefits, that there would be a continuation of health benefits beyond your retirement age is disappearing from a lot of workforces, a lot of workplaces as a benefit, and therefore, Medicare certainly has its gaps in terms of an ability to provide all of your medical care needs. So there is a need to continue in the workforce to continue to get that active health care benefit. So we're seeing as a very common reason that employees state as a reason that they're staying in the workforce beyond traditional retirement age is the need to continue the health benefits provided through active employment. We've also seen the Social Security full retirement age go up to guarantee the full benefit of Social Security, so people are staying later into their working life to ensure that they get that full benefit of Social Security. So a lot of reasons why this is happening. Another is just basic economic demand. We are seeing that a lot of folks who are maybe set to retire in 2010, 11, 12, up to today were so negatively impacted by the 2008 recession and a relatively slow recovery from the 2008 recession that retirement just was not a realistic option for them in a traditional retirement age, so they're staying in the workforce later. Or the expected growth of their retirement savings did not happen, in fact went the wrong direction for a little bit of time there, so there was a need to stay in the workforce a little bit longer to be able to be better positioned to manage a long retirement. That's why it's happening. We've seen the numbers, what's happening. What do we expect the impacts to be on employers of a workforce that is changing in such a significant demographic way? One is that we need to, as employers, develop strategies for retaining older workers. We need older workers to continue the workforce because we see that younger workers are not entering the workforce as early as they used to, and our demographic makeup of this country is changing, so the candidates to be your employees are changing. So there's a need to attract and retain older workers. So you are, as an employer, going to have to find strategies to do that, like accommodating part-time hours, accommodating work from home, accommodating phased-in retirements. Training on new technologies will be very important as our workforce becomes older and technologies change, not to a new user interface or a new version of some technology, but entirely different technologies, entirely transformational technologies. That's going to require a significant investment in training for all employees, but in particular for employees who have been accustomed to certain types of technology, certain types of equipment, certain types of tools, and now later in life are going to have to adjust maybe in a major way to how they do the job. Training will be a major component of that. So we are going to have to embrace this older workforce. These are some strategies that employers should be thinking about, across the board, not just from an OSHA perspective, but from an HR perspective, from an employment law perspective, good things that everyone should be thinking about. Knowledge transfer is also going to be a big, big deal for employers over the next 15 years. We have this sort of surge of senior workers who will eventually be retiring in big numbers, and then perhaps maybe a very big gap where there's not a sort of generation to generation handoff within your workforce because there's a glut now of senior workers, and there's a risk, therefore, of a great loss of intellectual capital. So there should be some strategies put in place now for how to, facilitate a knowledge transfer when we move from this senior workforce and then start to see the mass retirements, even if they are in much later years. They're going to happen, and they're going to happen when perhaps there's not a good or significant next generation to step in. So start thinking about those issues. We know that there are unique economic and social responsibilities that senior workers have that more junior workers do not have. So we need to again, start thinking about flexibility in our workplace policies to address some of those realities. Likewise, the personal health concerns, and we are going to talk about that in more detail from an OSHA standpoint, but just in general, we know that we've got senior workers will have different and perhaps more frequent health or more significant, catastrophic type of health events that need to be accounted for and prepared for in a way that perhaps we did not need to do or do not need to do with a younger workforce. Also, knowing that we'll have more senior workers means we'll probably also have higher pay levels. These are senior workers who have been with your organization for a long time. Pay increases over the life of the career, and you will be having a glut of employees in that range where they are at a higher pay level, and it won't be quite as balanced as it's been historically with generation making up an even split among your workplace. Likewise, health benefits are likely to be more expensive for senior workers than a younger workforce. And then there's also the risk of intergenerational conflict, and I see this as a OSHA issue as well, where there is either ineffective communication across different generations in the workplace, but also perhaps some resentment by younger workers who see a senior workforce that's not retiring at what they would consider to be these traditional milestone ages, which means there's not opportunity for younger workers to climb up the ladder. There's not seniority opportunities to be gained if the more senior workers are not leaving the workplace, which could create tensions and could create morale issues and possible issues with safety and health or some of the other employment law issues that Jordan's going to talk about. So that's just a general sort of business impact that I think this aging workforce will have. Now I'm going to talk about specifically the OSHA-related, OSHA and regulatory issues that are impacted by the aging workforce. I'm going to talk about the OSHA-related issues. Jordan's going to talk about ADEA, ADA, and FMLA issues as well. So let's think about, and then as a last thing before I get into the OSHA-specific issues are our workplaces prepared for what's happening, this changing face of our workplace? And I saw some really interesting data on this that I just wanted to share with you. The fact that you've all registered for this webinar, that you're here today, tells me that you're at least thinking about this, which is great because a lot of employers are not thinking about it at all. There was a really terrific survey done by the Society for Human Resource Management that found that organizations are woefully unprepared for this changing demography in our workplaces. But just over one-third, so that means two-thirds are not, but just over one-third of organizations have started to examine their policies and practices to address this demographic change. So two-thirds are not doing that. Only about 20% have examined their workforce and determined, or 20% have examined their workforce and determined that no changes in policies or practices were necessary. And they reached the conclusion, and I share the conclusion, that conclusion is probably not right. So you've got 20% who have looked at this and don't think any changes are necessary, and that's 20% of this only one-third who have considered it at all. So that means there's a heck of a lot of workplaces out there that really haven't even started to think about this, haven't done anything, haven't made any changes, haven't evaluated the need for changes in what is, I think, a sea change in what's happening in our workforces today. Another interesting data point here is that 2/5 of respondents indicated that the increasing age of the workforce had not prompted any changes in retention, recruiting, or management practices. So just those specific areas where we already talked about as a good best practice to start thinking about now, most of the respondents have not considered that at all. Even those that are thinking about this are not thinking about it in those terms, and perhaps they should be. So with all of that very lengthy introduction to the issue, because I find it to be a fascinating issue that I've seen anecdotally over my 15 years of practice, and to see this data is really, really eye-opening. With that, let's talk about the OSHA issues implicated by the aging workforce. The obvious place to start is injuries, injury data. Are older workers more susceptible to injury? What types of injuries are they more susceptible to? The data is pretty interesting in this area, and what we've seen is that it is actually older workers are less likely to be injured at work for a number of reasons. One is they have wisdom and experience, and they don't make the mistakes of youth, and they have learned lessons over the years that will help them avoid injury. It also is a factor of senior workers moving out of perhaps the jobs that expose them to more hazards. They're moving off of the front line into a supervisory role, from a supervisory role into a senior management role, or into roles that require less physical or demanding labor. So they are less likely to be injured in a general sense, but the injuries that they do suffer tend to be much more significant. And I don't mean necessarily significant in the basic consequence. It's not that they're more likely to suffer an amputation injury than some other employee. It's that if they are injured, it takes them longer to recover. It's more days away from work, more days in a restricted work status, more time receiving active medical care. So the costs of injuries to senior workers are greater total, even though there are fewer actual injuries to senior workers. So these are the sorts of things that will impact your OSHA 300 log, because an injury to a younger worker that may have them miss the rest of the day, take some Tylenol, back at work the next day, may not even be a recordable injury. That same injury, twisted back, shoulder, elbow strain, something like that, that injury to a senior worker now becomes a recordable injury because it's a days away or a job restriction, job transfer type of injury. So the injuries are more significant. They show up on your books more. They affect your workers' comp bottom line more. They affect all of your injury and illness metrics, which can have an effect overall on your business. This data here on this slide also shows the types of injuries that are much more likely among senior workers, and it's listed here as overexertion is one where there is the biggest difference between senior workers and junior workers, and that is really we're talking about the musculoskeletal disorders, the MSDs, the strains, back injuries, neck injuries, muscular injuries are much more likely, are happening at a much greater frequency among our senior workers than their junior counterparts. And likewise, falls on the same level. This is not, fall in construction from one level down to another. This is your slips, trips, and falls in the workplace are much more likely to happen among your senior workers, more likely to be reported by a senior worker because it's more likely to be impactful as well. A junior worker may slip, trip, and fall, not really be hurt, and not even tell his employer that it's happened. Senior workers, it's more likely to be reported, and also more likely to become a recordable injury because of the impact on the different impact that events like that have on senior workers. So with those types of injuries being the big focus, it makes sense today for me with you to talk about ergonomics issues, because that's where I see the biggest impact of our aging workforce. And if you don't know, on the phone with us today, ergonomics is the science of fitting the workplace conditions and job demands to the capabilities of the working population, making sure that the task fits the skills and capabilities of the employee performing the task. From an OSHA standpoint, OSHA ergonomics is about assessing work-related risk factors, or factors that may pose a risk of musculoskeletal disorders, and identifying ways to alleviate or eliminate those risk factors. That's when OSHA talks about ergonomics. They're talking about the employer identifying ergonomic risks and implementing ergonomic solutions. So OSHA and ergonomics. Musculoskeletal disorders are injuries to muscles, nerves, tendons, ligaments, joints, cartilage, spinal discs that are not caused by a traumatic event, not caused by a slip, trip, and fall, motor vehicle accident, something like that, they are resulting from strain, stresses, and repetitive workplace tasks, workplace motions. And here are some common MSDs: rotator cuff injuries, shoulder problems from a frequent or repetitive strain or stress put on your shoulder, lifting, moving, sorting, things like that. Muscle strains and back injuries that occur from repeated use or overexertion or work in awkward postures. Elbow, tennis elbow, tendonitis, carpal tunnel, trigger finger. These are all injuries to your muscles, nerves, tendons, things like that are not caused by a single traumatic event, but instead by either repetitive stress, overexertion, or work in awkward positions. So why is ergonomics such a big deal when talking about our aging workforce? It's a big deal because there are physical, musculoskeletal changes that happen in that happen to people, to humans, as they age. There's physiological and physical changes to our perception and cognitive abilities as we get older. And as a result of that, that has a greater impact on things like musculoskeletal disorders. Soft tissue injuries are much more frequent for older workers. Arthritis is a condition that is commonly associated with aging. Degenerative disc illnesses and conditions are things that happen over time as you age and continue to work in certain jobs. Sprains and strains are much more common in senior workers. And then other types of injuries can be more common because of some of the physiological changes in humans as they get older, like balance gets worse, reaction time slows, we start to have visual and audiological deficits. So slips, trips, and falls become more common because balance issues become more of an issue. And our reaction time and our ability to perceive and react and see and hear things that are going on around us in the workplace are diminished, so too are increased the likelihood of the types of injuries we're talking about, slips, trips, and falls, things like that. So these are the reasons why we're seeing more MSD-type issues in senior workers and issues that tend to linger and cause greater cost in the workplace. So what do we expect from OSHA in terms of ergonomics enforcement? It's been a really sort of strange area of the law from the OSHA perspective. There was, at the very end of the Clinton administration, a midnight rulemaking where an ergonomics standard was actually created and put into effect just as the Clinton administration was walking out the door of the White House. A few days later, the Republican Congress, after the Clinton administration left office, repealed by legislation, repealed the ergonomic standard. So it was never really implemented. And because it was repealed by enacted legislation, then it's something that OSHA cannot re-implement, cannot reintroduce an identical or substantially similar standard. So we don't really expect to ever see an ergonomic standard. But that doesn't mean that OSHA cannot enforce ergonomic issues, because OSHA has its general duty clause, its catch-all provision that requires employers to provide a workplace free of recognized serious hazards. And OSHA has historically looked at ergonomic hazards in certain workplaces as recognized and serious, and hazards for which a feasible means of addressing them can be implemented by employers. And so general duty clause violations have been issued for ergonomics issues. Looking at present day, the Obama administration, what are they doing about ergonomics issues? We've seen a few different things. One is OSHA, under the Obama administration, proposed a change to the injury illness record-keeping rule to add a musculoskeletal disorder column to the OSHA 300 log. And this would mean, it may already be a recordable injury. It is already a recordable injury that you've had a neck strain or a back strain, something like that has an employee out of the workplace for 5 days away. Well, now you also would have this separate box for MSD injury to check on the 300 log and to total at the end of the year on your 300A summary So it's a way to track and to point out and highlight, hey, there's a greater risk of MSD injuries in this workplace or performing this work task. And it's a way for OSHA to look at it and say, it makes their job of enforcing under the general duty clause much, much easier, because they can say, of course it's a recognized hazard. There it is on your 300 log. You've had 5 MSBs in the last year, so you should have done something about it, general duty clause violation. That rule is limping through OSHA's broken rulemaking process, and I'll tell you a little bit more about where that is and its likelihood of going anywhere. The other thing that we've seen the Obama administration do to focus on ergonomic issues is through some emphasis programs and enforcement initiatives. First was about a 5-year-long nursing home national emphasis program where ergonomics was one of the primary focuses, one of the hazards that was the primary focus of the emphasis program. That nursing home national emphasis program has just been retired and replaced now by the 2015 Healthcare Enforcement Initiative. And that Healthcare Enforcement Initiative is basically taking the nursing home national emphasis program and expanding it to other workplaces within the healthcare industry, so hospitals, outpatient services, and other healthcare settings are now being looked at from the same perspective that nursing homes have been for the last 5 years, where thousands of nursing homes were inspected under that program. And again, ergonomics is, issue number one in that enforcement initiative, looking at patient handling, lift assistance, nurses and orderlies and folks that have to lift and reposition and move patients or work with heavy equipment, x-ray technicians, things like that, the sort of things that can contribute to or cause MSDs in the healthcare setting are getting a really strong look, a lot of scrutiny from OSHA under the previous emphasis program and this new initiative. What we've also seen from OSHA under the Obama administration and in prior administrations has been a focus on ergonomics guidance documents. And this, theoretically, when OSHA puts these out, they put them out under the guise of compliance assistance. Hey, we're trying to educate all these different industries about what ergonomic hazards exist in their industry and identify some best practices for how they can address, identify, and eliminate those ergonomic issues. Well, these guidance documents, when they come out in your industry, it's a really helpful tool, and it is compliance assistance on day one, but what ends up happening is OSHA uses the existence of the guidance document to prove their general duty clause violations because, again, they have to prove recognized serious hazard with feasible means to address the hazard. Well, OSHA can point to its own guidance document and say, hey, poultry industry, we put out a guidance document that talked about all the work tasks in the poultry industry that expose employees to potential MSDs and identified some new tools, new practices, and solutions to eliminate those MSD, those risk factors. And we see in this poultry factory that you're not implementing any of the really good ideas that we OSHA presented to you in this guidance document. So while the guidance document is not the law, it's not a regulation, it's not a standard, but it is used as the evidence that OSHA needs to show that the industry knew or should have known about the hazard. It was a recognized hazard. And here were all these feasible means that could have been implemented to address it. So there's been a lot of new guidance on ergonomics by OSHA in the healthcare setting, in the retail setting, in manufacturing, and all of those tools are out there to help, but also to be used as the basis for enforcement. So look out for that and look for those tools and make sure that, see if there are any that apply to your industry, and if they do, you ought to seriously consider implementing all or some of the recommendations therein, because although they're not mandatory, OSHA is more or less treating them as mandatory through general duty clause enforcement. Already talked a little bit about how OSHA uses the general duty clause to enforce ergonomic issues. The second list here is pretty helpful to help you understand how OSHA, what OSHA looks at when they're evaluating your workplace from an ergonomic standpoint and whether to issue a general duty clause violation. They want to know whether an ergonomic hazard exists, whether it's recognized in your industry or by you specifically, whether it's likely to cause serious harm, and whether a feasible means exists, that's when they can issue a general duty clause. One other sort of unique element that we saw develop over the last, I think this case came out about 5 years ago, maybe 6 years, maybe 3 years ago. I'm sorry, it was 3 years ago. There was a case that changed OSHA's burden of proof in an ergonomics case, and the concept was that the work task does not need to be the sole cause of an MSD injury to be a recordable injury, to be work-related, such that it could be cited by OSHA. It just needs to be a cause. And it came up in the context of an employee who had a tennis elbow, a repetitive stress injury to his elbow, but this employee was also a very active tennis player. And other coworkers of his did not have this tennis elbow issue, but the review commission looked at this and said, well, it may not be the only cause, but we think the work task is at least a contributing cause. Therefore, we're going to accept that this is a work-related injury. So that affects your record keeping and affects, the ability for OSHA to cite something under the general duty clause. I think we already talked about all of this. This is where you're most likely to get a visit from OSHA related to ergonomics. You've got the National Emphasis Program, the Healthcare Initiative. You also have inspections of workplaces in industries with significant numbers of injuries related to ergonomic hazards under other emphasis programs, the old historical site-specific targeting program. And then, obviously, there is employee complaints, which still trigger a significant number of OSHA inspections. These are the types of hazards very often that will have an employee call to complain to OSHA, doing the same job over and over again. Maybe they've complained to the employer and nothing has changed, no lift assistance, no tools have been introduced. That's the type of thing that an employee is going to call OSHA and complain about, and then you'll get a visit and a potential general duty clause ergonomics violation. We talked about the guidance documents that have been out there. Here's an example of some of the specific industries that have one of these non-mandatory/mandatory ergonomics guidance: shipyards, poultry processing, retail, and grocery stores, nursing homes, meat packing plants, and others that you can find on OSHA's website or shoot us an email. We're happy to let you know if your industry is covered by either an OSHA-related ergonomics guidance or some other industry consensus documents, ANSI, or a trade association within your industry. If they've put out records like that, it is not unusual at all for OSHA to point to some guidance by an industry organization and say, you knew or should have known, your industry knew or should have known about this hazard, and you weren't addressing it, so it's a general duty clause violation. How to tackle ergonomic issues in the workplace. This is sort of the best practices, things you should be thinking about, things you should be doing. Here's how to identify a workplace condition that causes musculoskeletal disorders. There's a lot of different data points, a lot of different things that you can do to find out where these hazards, where these risk factors are in your workplace. You can look at your injury and illness data. That's a great point. I mean, that's what OSHA, that's why OSHA believes the 300 logs are out there. They're out there for you and for OSHA to learn where the hazards are. So if you've got, guys in your deboning room at your poultry plant who, three guys every 6 months miss work days because of, tennis elbow issue, that tells you there's a risk factor or potential risk factor in your deboning process. And you may need to look at that and come up with solutions. Periodic physical reviews and observations of your job sites to look for risk factors for MSD injuries. Look for, information out there from your industry trade associations or your industry peers about the types of ergonomic risk factors and solutions that they've identified. And certainly encouraging employee input is a great opportunity to hear from your employees where they find themselves doing a task that puts them in an awkward position or often requires them to overexert. And then look at OSHA's guidance documents if there are any that are applicable to your industry. So in addition to just identifying the risk factors, what do we do about it? Thinking about the preventive measures, you want to try to minimize lifting, minimize static work and muscle loading and overexertion. Consider restructuring job duties to either minimize or rotate to deal with those types of overexertion or heavy exertion types of tasks and activities. Consider flexible work hours. Think about more often doing audits more often to see if your solutions are being implemented, to see if there's opportunities for other solutions for preventive measures. Conducting job safety analyses on each individual task at the workplace. And then think about wellness programs and stretching programs. Things like that have been proven to have a pretty profound effect on those types of MSD injuries that have such a big impact on your workers' comp data, on your injury and illness data. So think about that. Certainly as your workforce changes in demography, becomes older, becomes more susceptible to these types of injuries, think about either implementing or enhancing wellness and stretching programs in the workplace. Talk real quickly about some record-keeping issues. At a basic level, the concept here why record-keeping is impacted by an aging workforce is that there is no eggshell exception to record-keeping. And what I mean by that is it doesn't matter if 99.9% of people would not have had the same result because of the injury that happened in your workplace, because of the incident in your workplace. 99% of employees wouldn't have missed work. 99% of employees wouldn't have had to go on job restriction or a job transfer. 99% of workers wouldn't have been hospitalized for the incident that occurred. Doesn't matter. If the employee, your employee, does have that result, it is a recordable injury. It is a reportable injury. It is a compensable workers' comp injury. So there is no eggshell exception. Means as your workforce becomes more susceptible to certain types of injuries, you're going to have more of those injuries that are going to end up on your record-keeping log, even though the same incident, same event, same task would never have had that effect on a more junior workforce. It does have that effect on a senior workforce, and you have to live with that in the context of OSHA record-keeping and the other regulatory areas we're talking about. So there is this geographic presumption. If it happens at work, it is almost certainly going to be considered work-related, except for a few circumstances. And if it happens at work, even if it is a senior employee who's more susceptible, you're still stuck with the recordable injury. So the other thing that is interesting now about this, things that are more likely to result in a hospitalization than they have historically with younger workers, is hopefully all of you are aware now of the new injury reporting rule that was became the law in 2014, became effective January 1st of this year, where the hospitalization of a single employee for medical treatment beyond observation and monitoring and diagnosis, hospitalization of a single employee has become a reportable event to OSHA. It used to be fatality and hospitalization of 3 or more employees from the same event was reportable. Now it's hospitalization of a single employee, which brings into play these ergonomics type of injuries, these slip, trip, and falls types of injuries, where an event like that would never hospitalize 3 employees from the same incident, but it very well could result in the hospitalization of 1 senior employee. And now you're picking up the phone to call OSHA. When you pick up the phone to call OSHA, you're much more likely to be inspected by OSHA. And when OSHA is at your workplace, it is very rare that they leave without issuing some citation. Under this new reporting rule, there's projected to be some 50,000 more events that are actively reported to OSHA than there were under the old rule. So again, more reports, more inspections, more citations. So an important factor here. I talked already a little bit about, and I'll just briefly mention the proposed rule, another proposed injury and illness record-keeping rule, to add this musculoskeletal disorder column to your record-keeping logs. Just tell you a little bit about what it would do. There would be a box on the 300 log that you have to check if the injury that results in days away or the injury that results in transfer is an MSD injury, and then you've got to total those up and add those to your 300-day summary. This is going to increase, potentially increase record-keeping violations, because it's just another obligation, another box to check that could be missed. and missing, potentially additional record-keeping violations, and certainly increases the risk of general duty clause violation because it draws attention to MSD risk factors in your workplace. OSHA would say it draws attention to you, the employer, and therefore you should be adjusting and making changes to your workplace and your tools and your practices to eliminate that. If you're not doing that and those trends continue of high numbers of MSDs, that creates a greater risk factor for you to general duty clause violations. Also, higher numbers of record-keeping instances, higher numbers of workers' comp reports, claims will impact your premiums and ratings, impact your ability to bid on government contracting. The record-keeping logs are generally included in requests for bids in private contracts and government contracts, so your logs are going to look a little bit uglier under this new proposed rule. Now, whether this rule is going to happen or when it's going to happen right now is listed in OSHA's regulatory agenda as undecided. What will happen next with this? So I think that means we're pretty confident saying it is not going to happen during the current administration. We may see something happen if we have another Democratic administration to follow it. Last thing I'm going to cover from an OSHA standpoint is occupational hearing loss. Obviously, OSHA has a hearing loss set of regulations that require you to take baseline audiometric readings and to record on your injury and illness log when you have significant losses from that baseline audiometric reading. In addition to this record-keeping issue, there's also a duty to implement hearing loss prevention programs if you have significant amounts of hearing loss or if you have exposures to noise at certain levels. The regulation allows you to take age correction values, which, in other words, accounting for natural hearing loss that may not be caused by workplace conditions, but which may just be caused by the natural hearing loss that comes with getting older. You can take these age correction values, but only up to the age 60. So now if we're looking at, like 150% increase in employees who are staying in the workforce at age 75 and over, you can no longer account for any special natural hearing loss for those employees. So you're going to have on your record-keeping logs and in your evaluation of your need for hearing protection, employees who are having natural hearing loss, but whose natural hearing loss you cannot account for when you look at changes in the audiometric baseline, the hearing loss values in consistent monitoring. So hearing loss is obviously another issue that is impacted by this aging workforce. So what should employers do from an OSHA standpoint, a safety and health standpoint, in dealing with an aging workforce? As I said in the beginning, embrace the aging workforce. You have to. That is our available workforce, and that's who you should be. You're certainly going to need them in your workplace, and there's great value. I mean, there's all sorts of, the experience, wisdom, institutional knowledge, loyalty, all the things that we know come with older workers as they age at your workplace. Those are important things. You'll want to embrace those. You'll want to keep those part of your workforce. But knowing that they'll be there and they have additional risk factors, you need to account for that. So, first thing is make sure you're maintaining accurate injury illness records. Things are going to change. More things are going to become recordable than perhaps you've seen in the past. And don't run from that. If it's recordable, it's recordable. We know that OSHA is looking harder and harder at record-keeping issues. They've introduced another record-keeping standard that will have you submit your record-keeping logs to OSHA on a quarterly or yearly basis. We know that they're trying to change the law to allow them to cite record-keeping violations and further back in time than 6 months. So make sure that you are, accurately and completely addressing the record-keeping changes that we know are going to come with more susceptible, more vulnerable workers. Implement preventive measures and wellness programs to account for some of the risk factors that we talked about with aging. Match tasks to abilities. Consider physical limitations and think about those physical limitations as you are assigning work tasks. And then obviously, and still, among these, all of these really relate to considering ergonomics. Conduct workplace audits to identify ergonomic risk factors. Design your work environments to take into account ergonomic concerns, such as better illumination, ergonomic workstations and tools, lift assistance tools, staffing older workers in less noisy areas, understanding that hearing loss is an issue as you age, and being able to hear is a really, really important component of having a safe workplace and being able to perform your work safely. So think about those things. Think about the unique physiological and physical issues that we know come with aging, and make sure that you're accounting for those as you set up your workplace and assign employees to different work tasks. So I am, with that, going to hand it over to Jordan. If you have questions about ergonomic-related issues, OSHA-related issues, and aging, type those into the chat box, and we'll address those.
Thanks, Eric. I'll jump right into the employment law implications of an aging workforce now, and I plan to speak for about 30 minutes, so we can finish right on time at about 2:30. Obviously, the first law that everyone thinks about when you're talking about the aging workforce is, of course, the Age Discrimination in Employment Act. And what hopefully most of you on this call know is that the ADEA protects employees and applicants 40 years of age and older from discrimination. So the ADEA does not protect you from any sort of reverse age discrimination. It doesn't protect younger workers. It also doesn't protect you if you, get quote-unquote discriminated against when you're 39 in favor of a 23-year-old. It only protects individuals 40 or over, at least from a federal standpoint, and it protects you in all aspects of employment: hiring, firing. The big one is compensation. And it also prohibits things such as statements and job notices or advertisements indicating an age preference. It prohibits denial of benefits to older employees, and requires that if benefits are reduced to older workers, that the same corresponding benefits must be reduced to younger workers. It also prohibits mandatory retirement in almost all private sectors. Under the ADA, it's also unlawful to harass someone because of his or her age. You can't make offensive remarks. You can't really say, "Oh, if you were younger, you'd have more energy. We need fresh blood around here. We need fresh ideas." Those things all can be indicators of age discrimination, and an employee can sue as a result of a hostile work environment, or much more frequently, an employee will wait till they're fired or any other adverse employment decision. Maybe they weren't promoted, or maybe their office was moved. Anything that could be an adverse employment decision, and then an employee will point to those comments to indicate that they were discriminated against on the basis of their age. The other real tricky thing with age discrimination, as opposed to race discrimination, national origin, sex, anything else, is that, as Eric pointed out earlier, an employee's seniority is often tied to his compensation. Typically, an employee who is older and is close to retirement age has been with the company for a long time and is paid a higher salary. So while, as an employer, you are entitled to terminate someone for any reason you see fit, if the reason is because he makes a higher salary, it is going to be a fact-intensive inquiry as to whether that is a subterfuge for age discrimination. So to minimize the risk of potential litigation, what I counsel almost all of my employers to do when they're terminating an employee based on age or even other factors is to provide some sort of benefits or severance in exchange for a waiver of liability of all claims, called a release of claims. The first thing when I ask my clients, though, is when they tell me they want to fire someone, is how old is the individual? Because unlike any other protected class, the Age Discrimination and Employment Act creates a whole hurdle of basically a bunch of hurdles that an employer has to jump over or through in order to provide a legitimate, valid, and lawful release of claims. This all started in 1990 when the Age Discrimination and Employment Act was amended by the Older Workers Benefit Protection Act, the OWBPA, which establishes a specific requirement for a knowing and voluntary release. And at first that sounds, fairly basic and common sense that you always want a release to be knowing and voluntary. However, the OWBPA outlines 7 factors that must be satisfied for a release to be considered knowing and voluntary, and these are tough factors and tough hurdles that must be addressed. And if a waiver fails to meet any of these requirements, the age claim can proceed and the waiver will be found to be invalid and unenforceable. So what are these 7 requirements? First of all, the release must be written in a manner that can be clearly understood. Again, this is fairly universal, and even if it's not an age-related claim, you want your waiver to be written in a manner that whoever is signing it can understand. You want to eliminate a lot of the technical jargon and long, complex sentences. So that's pretty standard. Number 2, however, you need to specifically refer to the ADEA. So if an employee is over 40 years old and hasn't even thought about age discrimination, your release must specifically point out that they are waiving claims under the Age Discrimination and Employment Act. Number 3, the waiver must specifically advise the employee in writing to consult an attorney before accepting the agreement. I have clients who want to try to get around this requirement and say, what if we say it's okay for you to consult counsel? That courts have found that is not sufficient. When you're firing an employee over 40 and providing them with a waiver, you must say, we hereby advise you to consult an attorney before accepting the agreement. You must also give the employee at least 21 days to consider the waiver. He doesn't have to wait all 21 days, but he has to be allowed 21 days to consider, which is quite a long time for the offer to be sitting out there. Number 5, which is really what I think is the craziest out of the 7 requirements, an employee has 7 days to revoke his signature. So if an employee tells you, yes, I am entering into this agreement, you'll give me severance in exchange for release of claims, and here is my signed agreement, you have to wait 8 days before doing anything, because on the 7th day, he can revoke and say, oh, you know what, I consulted with an attorney, I talked to a friend, I've decided I don't want to waive my claims anymore. 6, it can't include any rights or claims that may arise after the date the waiver is executed. That is similar to many other waivers. And also similar to other waivers, the agreement must be supported by consideration in addition to what the employee is already entitled to. If under some sort of prior agreement he was already going to receive a certain amount of money, you might want to consider providing a little more so that the actual age discrimination waiver has separate and additional considerations. There's also additional OWBPA requirements for what's called exit incentive programs or other employment termination programs. And what I mean by that is clients often ask if they can institute some sort of voluntary incentive retirement program. As I said before, mandatory retirement programs are unlawful. It is not unlawful to have some sort of voluntary exit incentive program where you offer 2 or more employees additional consideration to persuade them to voluntarily resign. Again, however, or obviously you can involuntarily terminate a group of employees. But for both of those scenarios, there are additional requirements in addition to what I just those 7 requirements I just laid out. Specifically, now you must provide the employee 45 days to consider the waiver. If you thought 21 days was long, 45 days is obviously twice as long for that employee or that group of employees to consider the waiver. You also, on the release form that the employee will get and hopefully sign, the ages and job titles of all the individuals who are selected for this program or who are eligible for this program must be listed. So an employee will see that, 10 people who are over the age of 40 were selected for this program. 1 person who was under the age of 40 were selected for this program. I wonder if I have an age discrimination claim. So it's really, if you're going to enter into one of these voluntary exit incentive programs or other employment termination programs, you really have to be careful and know about these additional requirements and make sure there is some sort of business justification for the requirements, given that the OWBPA makes transparency such a paramount reason for these employees to be able to consider whether or not they have been discriminated against. I have seen many age discrimination cases where I really don't think the employee was considering age discrimination, but based on these burdensome requirements, they got the idea in their head that there may have been other factors aside from legitimate business reasons which caused their termination. Okay, that's really just the outline of what you need to consider for knowing involuntary waivers under the ADEA. I now want to move on to the disability discrimination and really kind of the intersection between the ADA and FMLA and how those laws relate to our aging workforce. As most of you know, Title I of the ADA, which is the ADA in employment. There are all other parts of the ADA that deal with public accommodations and the government, but for private employers, Title I of the ADA prohibits such employers from discriminating against qualified individuals with disabilities in all terms and conditions of employment, job applications, hiring, firing, advancement, compensation, similar to the ADEA. It applies to both applicants and employees. It also prohibits retaliation on the basis of a disability. The paramount question and issue here is that an employer is required to reasonably accommodate qualified disabled individuals as so long as the reasonable accommodation does not cause you as an employer to have an undue burden. The ADA applies to employers of 15 or more employees, and to be protected, an employee must have a disability that is defined by the ADA as a physical or mental impairment, or someone who has a history of an impairment, or someone even who doesn't have an impairment if the employer regards that person as having an impairment, or if that person is perceived by others as having an impairment. At this point, in 2008, the ADA was amended by what's now called the ADAA, the ADA Amendments Act. And based on this act, it is much easier for an individual to establish that they are disabled. We used to write motions to dismiss and motions for summary judgment all the time, questioning whether an employee was actually disabled. At this point, courts have essentially straight out said, you don't want to do that. What you want to do is assume the individual has a disability and assume they have some sort of physical or mental impairment that substantially limits a life activity, and then determine whether or not the employer engaged in the interactive process to determine a reasonable accommodation. Here are some more definitions of physical or mental impairment, and I've listed out some of the general ones that I think everyone would know: deafness, blindness, neurological difficulties, cancer. But what I haven't listed here are the more innocuous ones that not everyone would realize are disabilities, but right now courts have said universally they are disabilities. ADD is considered a disability. PTSD. Someone just saying they suffer from depression or anxiety may be considered a disability. IBS, and any sort of stomach issues are typically considered a disability. However, it is possible, someone who just has a difficult personality. You may have an elderly person in your workforce who is cantankerous and has trouble getting along with others. He probably is not disabled, although you will have to be really careful here because it's possible that he could at least attempt to demonstrate that he has ADD or ADHD or some other impairment that rises to the level of a disability, which is causing him to act in the way in which he's acting. Also, an important note from this slide is that impairments that are episodic or in remission still may be considered a disability. So it's not a defense to say, well, he has cancer, but it's in remission right now. Here are major examples of major life activities, which I don't want to spend too much time on that. Obviously, hearing, eating, seeing, sleeping, walking are all major life activities that could be impaired. So, as I said earlier, the big issue is the employer needs to at least consider an older worker's request for a reasonable accommodation. Note, I didn't say you have to grant his request, and you certainly don't have to grant the specific request that is made, but you have to consider it. Note that a worker does not have to say he needs a reasonable accommodation. There's no magic words. He just has to indicate to you in some way, shape, or form that he is having difficulty and that he needs help from you as the employer to accommodate him. Again, assume he qualifies as disabled, and you must avoid immediately rejecting any requests for a reasonable accommodation. You must at least say, I understand your request, I'll take it under advisement, I will speak with whoever I need to speak with, and then we will reconvene shortly. And once you reconvene, that is what is called the interactive dialogue about the reasonable accommodation. You can ask the employee for details on how his proposal would work in practice. You could, if his proposal isn't feasible, try to respond with some sort of reasonable alternative. Try to get buy-in, if at all possible, from the individual. And very important, document all discussions so that if there is some sort of ADA claim, you have documentary evidence showing what you considered and what you tried, what he requested, and what you tried to do, and what you actually implemented. And continue to request documentary verification from the employee so you know what actually needs to be accommodated. The issue that's come to light recently is, what if an employee doesn't always show up for work? Is regular attendance an essential job requirement that needs to be accommodated? And luckily, most courts have found that attendance is an essential function. So if a plaintiff has a disability which prevents him or her from regularly attending work, he cannot perform the essential functions of his job, and thus he is not protected under the ADA. It is key to communicate this in job descriptions. It is paramount to list attendance as an essential job function, so there's no debate later on, further down the line in the lawsuit, whether an attendance is an essential job function. Also, punctuality, the EEOC has actually said that punctuality is not an essential job function, but luckily most courts have agreed with the courts that look at attendance as an essential function, and they have ruled that punctuality also is an essential job function. However, what obviously is more prevalent now than even a few years ago is telecommuting. Many employees ask, oh, can I work from home for a few days a week? That'll really help with my stress. Driving to work really causes a lot of stress. So I'd really like you to award me a telecommuting option for 2 days a week. And again, you need to consider this option. You might not need to grant it, depending on your industry. If your industry requires a lot of face time, it certainly would not be feasible. But if it's in the IT industry and you're working on behind the scenes on a computer all day, maybe telecommuting is potentially a reasonable accommodation. And in that situation, an employee may really be able to demonstrate that he, as an employee, and you failed to reasonably accommodate a request that was not an undue burden. So it is a request you need to consider. You need to discuss with the employee. You may want to look at the employee's job descriptions and see whether attendance is listed. And as I said, if it's not listed, you may want to add it. So in case you don't want to provide telecommuting options, you want to check an employee's performance reviews. If some supervisors have said that he's not a good employee when he's not supervised, that is certainly a legitimate reason to deny a telecommuting request and see if there's another reasonable alternative for his request. Maybe it's coming into work a little late. Maybe it's changing hours. You do not have to grant an employee-specific request. It is the employer who has the final say in what accommodation to provide an employee. Again, I've covered most of this, but just so you're clear, an employer must provide a reasonable accommodation for a qualified disabled employee unless it is an undue burden to do so. A leave of absence or telecommuting may be a reasonable accommodation if it allows the employee to return to work and perform essential job functions. If an employee is on a leave of absence, an employer must give the disabled employee the same benefits as a non-disabled employee who is on leave. And if an employer is on leave and he's not covered by the FMLA, the employer does not have to continue to pay for health insurance during the unpaid leave. And now I'm going to start dovetailing into the ADA and the FMLA to wrap up this presentation here, because they are, as you'll see, they overlap, and there's a lot of interrelations between the ADA and FMLA. Both the ADA and FMLA allow limited medical inquiries by you as the employer. For the ADA specifically, the inquiries must be job-related and necessary for the business. can ask for documentation of the existence of a disability, especially if leave is requested as an accommodation. And the FMLA certainly allows you to require medical certification of the need for leave, assuming it's related to the condition that they are asking for the leave. Just a little more about the ADA, about when you can ask about a disability. Applicants, when someone is the first applying, you cannot ask about disability-related questions. However, the big thing here is after a conditional offer of employment is made, at that point, inquiries and even certain medical exams are permitted as long as all new hires for that position are subject to the same inquiries and medical exams. And then during employment, inquiries and exams are prohibited unless, as I said earlier, they are job-related and consistent with business necessity. The question I often get from some of my clients is, how can we respond when employees ask questions about a coworker with a disability? And hopefully you all know this, but you cannot disclose medical information. That not only would violate the ADA, there's all sorts of other laws, GINA, HIPAA, and other privacy laws that could be implicated. But you can explain to others that you are acting for legitimate business reasons or in compliance with federal law. As for reinstatement rights, I'll get into the FMLA reinstatement rights in a minute, but just know the ADA gives employers greater reinstatement rights than the FMLA. Basically, the FMLA mandates that you return an employee to the same or an equivalent position with the same seniority, pay, seniority, and benefits. Under the ADA, and if an employee goes out on leave, the employer must reinstate the employees to their original position unless the employer can demonstrate that keeping the position open will cause an undue hardship. So if you have a 70-year-old employee who has to take leave for, let's say, for hip surgery and is out for a few months and you grant the request, when he comes back, you can't say, well, we filled that position and we're going to put you in a similar position. You must return that employee to that same position unless you can demonstrate an undue hardship. So just to review under the ADA, you really want to review your policies and your handling of ADA issues to make sure that you currently don't have policies right now that adversely impact older workers. You want to make sure you update job descriptions and other forms that mandate that attendance is an essential function so that employees don't take advantage of the fact that they could potentially work from home and not come in if it is an essential function. And really train managers, supervisors, and HR personnel on the new and expanded scope of the ADA and specifically how all these potential impairments that may not have been disabilities years ago, lots of impairments related to employees who are now older, years ago would not have been able to say they were disabilities. Now they can clearly, under the ADAA, qualify as a disability. And as a result, you really want to put a greater emphasis on the reasonable accommodation process and the interactive process. Real quickly, because I don't want to run too far over, I just want to touch on a few things with the FMLA. As most of you know, eligible employees under the FMLA are entitled to unpaid leave of 12 weeks for a serious health condition, which, similar to what we were talking about with the ADA, it's a broad definition that really includes pretty much any sort of illness, injury, or physical or mental impairment, especially if there is any sort of inpatient care or some sort of incapacity. If an aging worker tells you that he's undergoing continuing treatment by a healthcare provider, he's going to qualify for FMLA leave. And when he qualifies for FMLA leave as an employer, you're required to provide him with 12 weeks of job protected leave. It may be intermittent or it may be all at once. And you can require employees to use accrued paid benefits if the employee wants to be paid for some of it. And you must provide the same health care coverage and benefits during the FMLA leave. Remember, the employee is still an employee during the FMLA leave, so you cannot treat him as a non-employee during that time. With older workers, employers are likely to see an increased use of intermittent leave. And if possible, as an employer, you should require at least 30 days notice for an intermittent leave so you can really plan to have other employees covering this employee's shift, if at all possible. You certainly can require the older employee to work with you to schedule the intermittent leave if it's foreseeable. You certainly can require medical certification of the older employee's need for FMLA leave. And you can request an estimate of how often the employee needs time. And importantly there, you can request an estimate not from the employee, but actually from the employee's healthcare provider. And if there is doubt of the FMLA need for FMLA leave, you can ask for a second or third. You can ask that he sees a second opinion from a different healthcare provider. As I mentioned earlier, the FMLA requires reinstatement to an original position or an equivalent position with the same seniority, benefits, and pay. The last real substantive thing I want to talk about here is the interrelation between the ADA and FMLA. And what happens is once an employee goes out on leave for 12 weeks under the FMLA, and then the 12 weeks expires, employers think, okay, he's exhausted his FMLA leave, we can now terminate the employee. And while that used to be an accepted practice, it is no longer acceptable to do that. What you must do is go into quote-unquote ADA accommodation mode after the 12 weeks. So the employee has satisfied his FMLA eligibility. Now we need to consider whether or not he is disabled and whether or not additional leave can be granted as a reasonable accommodation. And most likely, it would be considered a reasonable accommodation, so long as it's not indefinite. If the employee can demonstrate he only needs a few more weeks and then he can come back to work, you'd really be risking it under the ADA by not allowing the employee to take that leave. So again, employers get confused because they say, well, under the FMLA, his 12 weeks of leave expired, but you really need to then think of it as an ADA question, not as an FMLA question. I just got a question regarding whether the FMLA, the 12-week FMLA is over an individual's course of employment or 1 year. And just so you all know, it's 12 weeks each year, if I wasn't clear about that. So under the law, it's unpaid, but you do have to provide an employee with 12 weeks per year. So my final slide here is just for effective strategies going forward. Make sure you communicate with the employee and monitor the FMLA leave. If the employee is over a certain age and you're not sure if he's going to come back, communicate with him and just make sure, don't ask, are you coming back or not, but just touch base with him and indicate your desire to have him return and monitor so you know whether or not he is coming back so you can plan your business going forward. Require medical certifications for health-related leaves to determine eligibility for FMLA, ADA, or both. When FMLA leave is up, and again, this is the important one, make sure to determine if the employee is eligible for further ADA leave. And ensure that your reinstatement policy allows a worker, especially if it's an older worker, but this is for all workers. They need to be able to return to the same job, not just the equivalent, if the employee is covered by the ADA. If the employee is covered only by the FMLA, it can be an equivalent position. And that is all that I have for you from an employment law perspective. I've only kept you 7 minutes past the scheduled time, so I apologize for running a few minutes over, but I just really wanted to touch base on these few issues with you. If we could get into so much more depth on all of these issues and many other issues that affect and relate to the aging workforce. But I just wanted you to have a general overview of the issues you need to be aware of that, as Eric pointed out in the beginning, are going to continue to become more and more prevalent in this day and age. If you have any more questions from Eric's OSHA presentation or my employment law component of the presentation, our contact information is up on the slide right now. Feel free to send us an email or give us a call, and we will be happy to address your questions going forward.
Well, thanks everybody again for joining today. This was, I thought a really interesting presentation. Thinking about it, preparing it, and delivering it, and then hearing Jordan's employment law component of it as well. There were a couple of questions that came in by email, or by chat. Tried to address those by chat as well, and some verbally. If you have other questions, please don't hesitate to reach out by phone or email. Like I said, we will be following up with an email to all of you who participated with a link to the recording of the presentation and a copy of the slides. And that might be a good opportunity there. If it triggers any other questions, feel free to shoot us those questions by email or give us a call. I don't want to speak for Jordan, but hopefully you could tell from my presentation today, or if you've participated in others with me, I'm a huge OSHA nerd. I love talking about this stuff. I love hearing about your experiences with this. So please don't ever hesitate to reach out if you've got questions, comments, you want to share a story, just talk about these issues. Please reach out. I love talking about it. It's how I learn my craft and understand what's affecting employers out there. So we're here and we're invested in this topic and all the others you've seen us write and talk about. Would love to talk to you more about it. So thank you again for joining us. I would invite you to participate in future webinars that we have coming up. I think there's at least 3 or 4 more on the OSHA front. I know the employment team is putting together a second half of the year agenda. It'll be up on our website soon. We'll make sure you hear about all that. And again, thanks for joining us, and we look forward to talking with you again, either in this sort of faceless webinar format, or hopefully meeting you and talking with you soon. If there's ever anything that we can do to help. So thanks for joining us. Bye-bye.